Throughout San Diego County, if you apply for a concealed weapon permit, you're asked to show good cause other than self-defense. But last Thursday, a three-judge panel of the Ninth Circuit Court of Appeals said the law infringes on a citizen's Second Amendment rights. If the ruling sticks, it could change gun management laws throughout the state. But the county sheriff says existing laws are still in effect. Here to help give this ruling some context is attorney and legal analyst Dan Eaton. Welcome back to the show.
Thank you very much, Peggy.
Now, Dan, remind us of how this lawsuit came about.
An independent journalist, Ed Peruta, wanted to have a concealed weapon in his home. He applied and was turned down. Why? Because he didn't meet the good cause requirement under San Diego County policy, which was very, very restrictive. Essentially, you have to show a specific threat. And he said, no, it should be enough that I am a lawful abiding resident of San Diego County who wants it for the lawful purposes of self-defense. The county said no, and he sued. And
let's get back, we'll come back to this because right now the requirement is you have to you have to have good character, you have to get a background check. I believe you can't be a felon, you have to have weapons training, but this good cause is at the heart of this lawsuit. What is the legal definition of good cause?
Well, that's the interesting thing. There is no legal definition of good cause. The good cause is defined by each county and municipality under California state law. Other counties define it differently from San Diego County, and it was San Diego County's very restrictive definition of good cause to get a concealed carry weapons permit that led to this lawsuit.
Following the appeals court ruling, Police Chief Lansdowne released this statement. I'll read it to you. It says, I think we need responsible gun control. I think the safeguards currently in the CCW process are reasonable and effective, where you have to show cause to carry a gun, not just because you want to. But Thursday's ruling doesn't mean it's legal right now to ignore San Diego County's rule that you have to have a permit and you have to qualify for that permit, correct?
Well, not according to the Sheriff's Department. That's exactly right. The Sheriff's Department has said we're going to leave the existing policies in place until the whole legal process with this opinion is worked out. So for right now, the good cause requirement, restrictive though it is in San Diego County, will continue to apply.
Do we know for how long, until it goes to the Supreme Court or comes back?
Well, ultimately, of course, if the Supreme Court ultimately rules on this, that's when it will ultimately be decided one way or the other. But for now, the rules in place remain in place.
Under the new law, who would be eligible if it goes all the way and actually gets to be reversed here? Who would be eligible to carry a concealed weapon in San Diego County?
Peggy, it's important to remember that the basic requirements that you mentioned, the good character, the background check, would not be affected and were not challenged. But good cause, that requirement would be satisfied simply by saying, I am a law-abiding resident of San Diego County, and I need this for the lawful purpose of self-defense. That would be enough. This other business of having a specific threat would go out the window.
And coming back to that, it's really boils down to this idea over the right to bear arms, whether it's concealed or open. Talk a little bit about that here in California, why that's an issue.
It's important to understand that the Second Amendment says a well-regulated militia being necessary to a free state, the right of the people to keep and bear arms shall not be infringed. So the key issue there is bear. What does it mean to bear an arm? And the court, the 2-to-1 decision in this very lengthy opinion, said, look, bear means to carry outside. It said if California says you cannot carry it openly, you cannot restrict the right to concealed weapons so much that you obliterate the right to carry guns or firearms outside for the purposes of self-defense.
To bear arms.
To bear arms. It's not just keeping it in the home. That's right.
How significant is this ruling for pro-gun advocates?
Well, it's an important decision because it's an extension of the Heller decision, which was the landmark decision in 2008, the U.S. Supreme Court, which recognized an individual right to keep and bear arms. Now, the focus of that decision was on the of holding a gun for hearth and home. This extends it to outside of the home, and there is a split now in the United States Courts of Appeals that the Supreme Court may very well ultimately have to step in to resolve because they don't want the Constitution being applied one way in one place and another way in another place.
Where does this case go from here? Does it go to the Supreme Court?
There are two possible places. One, there's no further challenge to this opinion. I find that hard to believe, in which case it would go back to San Diego Trial Court to enter the order as it said. The other is that a fuller panel of the Ninth Circuit, about a dozen judges, could decide whether this panel got it right. And whatever happens with that process, next stop, the Supreme Court to decide who is right. Is there a fundamental right to bear arms outside the home? And if so, are San Diego County's restrictions too much to allow that right to have any meaning?
And again, you think the Supreme Court is ripe to hear this because of the differences in various jurisdictions?
Exactly right, because there are other circuits that have reached a different decision. In fact, 3 circuits have reached a decision other than the one in the Ninth Circuit. And the Supreme Court may said, look, guys, we're going to step in and make this uniform from sea to shining sea. And that is where ultimately this issue is going to go.
All right, Attorney Dan Eaton, thank you so much for
All
your
right,
perspective.
thank you, Peggy.